And so to start this dialogue, we thought it was important to bring together members of the justice system, including lawyers, law enforcement, with community advocates that work with survivors of sexual violence. And we created our panel, who you will introduce shortly, with this in mind. And we're also very pleased to see in the audience today members of the community, members of the bar, members of the judiciary, MHAs, members of the media, and also members of the general public. It's very important that we involve absolutely everyone in this important discussion, and we find ways to move forward in collaboration and to support survivors of sexual violence. We really like to emphasize that our intention is not for this tonight's panel to be one-time event. As I've said, and I'll continue to say, this is a start to a dialogue. So we plan on following up with tonight with additional sessions in the near future, and plans are already in the works for another public event on the topic with retired members of the judiciary. In addition, we recognize that the unique challenges around this issue that are prevalent in areas of the province outside of St. John's, especially in rural and northern Newfoundland and Labrador. We are making plans to hold similar events and discussion in additional locations in the province and in the near future. And now I'd like to actually welcome the Minister of Justice and Public Safety and the Attorney General of Newfoundland and Labrador to say a few words.
Well, thank you, Nicole, and thank you, Kevin. And it's an honor to be asked to be here tonight during Sexual Violence Awareness Week and to be here for this panel. And I don't have anything prepared. I just wanted to say that I think this is a fantastic opportunity for me to be able to, instead of be up here talking, to be sat at a table there listening. And I think that's the most important thing that I can do, being in the position that I am now, which I've been in for a short period of time. I'd like to thank, again, Nicole and Kevin and all the organizers for putting this event together. And looking at the panel here, I know many of the people involved, and you've got a great panel here. So I'm looking forward to this conversation and listening to what they have to say, listening to the questions. And hopefully we can take something from this and help make the system better. And I'm also very glad, I'm looking at a full audience here. I think that's absolutely tremendous that we can see so many people here to talk about such an important topic. I think we all know that there are limitations within the justice system. That's not a surprise to anybody. But I also think that we should get across the message that we can change, and we're willing to change. We're willing to listen to ideas. And we've already talked about trying some just here in this province, whether it's the legal advice for those that are victims of sexual assault, something that's been tried elsewhere, and I think we can do here. I think this is something that's worth trying. But again, in order to get these projects and these pilots to work, we need to talk to people that, again, have the experience and the background necessary to make it worthwhile. And that's why, again, just dealing with Nicole and Kevin, they've been so helpful, and I'm looking forward to many more opportunities to sit down and talk. And just recently, actually, I had a ride-along with the RNC. And when I was riding with the officers, one of the things that actually was mentioned to me was the Family Violence Protection Act, which again is a good piece of legislation, is well-meaning, but it's been there for some time, and it's, from what I'm hearing, it's in need of revision. So these are the things that when I hear the ideas, what I'm committing to everybody in this room and to everybody out there is that I'm willing to listen and willing to try to change to help improve the system. But in order to do that, I need to hear from people. So I look forward to that. I look forward to discussion. Thanks so much for letting me be a part of this and to be here. And I wish everybody the best, and I wish our panelists the best as well. Thank you so much.
So we're going to begin. I'm just going to pose a question to our first panelist, Janet. Roughly we have about 7 minutes altogether for some of these questions. So we're going to help guide and just moderate that a little bit so everyone has an opportunity this year to air. But Janet, our first question we have, thanks Kevin. Yep. What are the concerns and the experiences that have been expressed to you by survivors of sexual violence about their experience in the justice system?
Honestly, there are so many that it really is challenging to even know where to begin with this question. I think the main two that we hear most often is around the prevalence of secondary wounding and a complete lack of access to justice for survivors. We often, as a community, scrutinize survivors of sexual violence in a way that is both unique and unjust. And a lot of people don't understand the societal context which allows sexual violence to happen. A lot of this context is based on myths and misconceptions that foster rape culture. Holding on to myths about sexual violence is incredibly dangerous because it perpetuates victim blaming and secondary wounding, which ultimately blames the survivor for the assault, which in turn fosters self-blame, guilt, and shame. And there really are countless misconceptions about sexual violence. What we sometimes see happening in sexual assault investigations and cases is that victims may not be believed, therefore cases are not always investigated appropriately, offenders are not punished, and victims experience ongoing re-traumatization. Many survivors also express great concern with the length of time to get through the process and lack of information about the timeline or case itself. For many, one of the only consistencies is that there will be delays, a lack of information, and a lack of communication. The legal system is often inaccessible to those who are marginalized, stigmatized, and/or living in rural areas. The more isolated the survivor, the more barriers that exist. And in most cases, perpetrators are known to the survivor, such as a parent, a partner, a coworker, or a friend. And this can create a lot of problems and isolation within social circles, a lack of confidentiality, and dissolution of third-party relationships, amongst other issues. Many people might have willingly engaged in drug or alcohol use prior to the assault and feel like this calls the validity of their experience into question. But there are also a lot of other reasons why someone might question whether or not their experience constitutes sexual violence. And on this note, it's important to remember that the one common element of all forms of sexual violence is that consent, which is mandatory all of the time, was not present. And consent is a voluntary agreement that is given willingly to a specific sexual act at a specific time. It's a full-body experience that can be expressed verbally or non-verbally, and it is mutual and continuous. Sexual violence really is about power and control, and becoming involved in the justice system for some can be incredibly empowering and a way to take some of that power back. However, for most, there is a lack of control over and over again due to a lack of understanding of the legal process itself, a lack of empathy from service providers and stakeholders, the inability to make decisions that are right for them in the moment. And there's also a dehumanizing aspect of a survivor being a witness to a crime in the criminal process. Many have expressed that they are not being involved as a person, but rather as a spoke in the wheel, not the center of it. Many people feel an unfair amount of responsibility and pressure to keep the community safe or get the perpetrator off the streets, and yet are offered very little support throughout an incredibly adversarial process. Survivors of sexual violence are particularly likely to be monitored for their innocence and the degree of that innocence in the incident or assault itself. The expectations that individuals or systems are there to help, and the reality is actually very different. And it's important to note that most of the people that reach out to us for support are actually not going through the legal process because they themselves have identified insurmountable barriers within the system.
So on that point then, Janet, what are survivors saying they need in terms of support with the justice system?
Again, I would need a lot longer than probably what's 3 minutes left to respond to this question. But it's really important to know that there really is no right way to work through experiencing sexual violence. Every person is an individual and will respond individually. Common things that we're hearing at the center is that we need to be breaking down so many of the barriers that I've already mentioned. But survivors and survivor advocates are continuously asking for sexual assault trauma-informed counseling, which recognizes that the compounded stress created by all of the barriers leads to many of the people that are reaching out to us having concurrent issues with mental health, addictions, poverty, etc. Sexual assault nurse examiners or other specially trained medical personnel need to be available province-wide. There needs to be a coordinated, informed response from all levels. This includes the survivor's personal support system, the police and medical personnel, community advocates, counselors, lawyers, and judges, which means there needs to be better communication between all levels, with each other, and more importantly, with the survivors themselves. Coordinated approaches to response, specifically through regionally specific sexual assault response teams. And a great decrease in the amount of secondary wounding and victim blaming that is happening every day. People in the community are also generally asking the wrong questions. We're continuously asking survivors why they don't report, or why did they recant, or why were they an uncooperative witness. Instead, we should be asking what is going on in our community and our society that allows so much sexual violence to happen. Where is the education on sex, healthy relationships, and consent? And what can we as individuals and a community be doing to better support survivors? Because we ask so much of them. We're putting so much responsibility on the backs of survivors. We're asking them to hold perpetrators accountable, to keep the community safe, and to go through the legal system without really asking ourselves, what is it about the system that isn't creating space for survivors to report? What is going on within the system that leads people to recant? And what could make the system easier to cooperate with? Furthermore, what's being said around the dinner table, in the schools, and within the halls of justice that is creating so many barriers in the first place? What are we saying, doing, and communicating that is leading so many survivors to blaming themselves for a crime committed by somebody else against them? For those who choose not to report, which is 100% a valid choice, we ask them to take on the burden of responsibility if their perpetrator commits another crime. And for those who do report, we ask them to continuously recount their experience, to undergo scrutinizing and sometimes traumatizing cross-examinations, to lose so much. And for what? Recent statistics show that only 3 out of 1,000 perpetrators are ever convicted. So what can we be doing better? We can be listening and asking ourselves, what does it truly mean to listen? Because it requires a shift in perspective, patience, and honoring that person. We need to be believing that survivors are the experts in their own lives and that they will make decisions that work for them in the moment. And we need to support. Healing is a process. It is a journey. It is not an event. We need to allow survivors the time and space to go at their own pace. We need to create safer spaces where they can be kind to themselves and receive non-judgmental support. The theme for Sexual Violence Awareness Week this year is listen, believe, support. These are not simply 3 words. They are a culture shift in how we react, how we respond, and how we support.
Thank you very much, Janet.
Thanks, Paul. So the first question we have pertains to police officers are often the first point of contact for a survivor of sexual violence. We'll have generally in the justice system. I'm wondering if you can tell us what the responsibility of the police to provide a full, accurate picture to survivors about what their experience in the justice system may look like.
Yes, quite often we are the first contact for people coming into the justice system. So for a lot of people, they don't have any awareness of what the procedure will be from the moment on. Quite often we're fortunate that somebody from Janet's organization or another support person can come in with a person who wishes to make a complaint to the police. So that's a big benefit to those people, but not everybody has that support when they come in. So it is a responsibility for officers to sit down with people who want to make a complaint. If it's a sexual assault or sexual violence, we think it's very important that we be realistic in the expectations of what the system is going to look like down the road and what it's going to look like from that moment on. I guess we have to try to balance between overwhelming a person who comes into us and trying to give them a complete picture. And I often think about a recent diagnosis, a family member who was told he had cancer. And after a traumatic experience like that, everything that was said after that, he did not remember a thing. So it's an ongoing process that a person comes in and asks a question about what the process is going to be like. And we can explain it, but we have to remember keep that relationship with the people and make sure that we continually tell them what the process is going to be like. We don't do this alone. We certainly use victim services. We use lots of community support groups to make sure that message gets across. But it is something that we do need to, and it's a resounding theme, to make sure that we keep in close contact with the people who make these complaints to the police. We need to make sure that the victims' wishes are honored, that we listen to what they have to say to us, we listen to what they tell us, and we try to incorporate their needs and their wants as much as we can, understanding the system and going through the system. Of course, as police officers, we have to be independent in a criminal investigation. We have to try to balance our independence, our investigative as we prepare potentially a case for court, but we also have to be supportive, make sure that the victims are respected and they know what their options are. We recognize there's other community groups that provide a lot of services. We need to make sure that the people are aware of what options are open to them. And of course, we always have to make sure that we provide this information in an easy to understand dialogue that everybody understands, because everybody grasps things in a different manner, in a different way. So we have to make sure that we communicate effectively with everybody. Many different ways to assimilate information, so we have to make sure that we relate to everybody as best we can.
Thanks, Paul. Kind of speaking to the person going through the system, what changes can be made to allow police officers to continue providing support to a victim throughout the whole legal process? Is there anything you recommend or any ideas you might have on that?
I guess that's really the point why we're here tonight. I had a good discussion with our Chief James, before I came, and we just talked about the changes that we've made over the last, well, I've been a police officer for about 31 years. And the number of changes that we've made over those 31 years has been immense. We've been very lucky to try to improve the service that we give to people in the community. We try to improve the way that we interview people, the way that we interview children, the way that we interview victims of sexual offenses. We've created an investigative unit that is specialized in interviewing witnesses, victims, also suspects, and also in training all of our officers in proper interviewing procedures. Interviews with children is extremely sensitive and needs to be done appropriately and right manner. Our number of female officers that we have over the last 30 years has certainly grown, and our intimate partner violence unit has been created in the last number of years, and we've had great support with the Women's Policy Office, with the provincial government to make sure we deliver specialized type of response that's needed in the community. We use our crime analysts. We have a very professional relationship with Memorial University, with the School of Social Work. We're continually trying to be more accountable to the community, and trying to keep everybody engaged by having our officers sit on committees and be involved in the community as much as they can and bring some feedback. So over the last 30 years, we've made lots of changes. We're certainly here tonight to listen to what people are saying needs to be changed. I mean, Janet just talked about the communication with our victims, and that's something that's always needs to be strengthened, and we always try to reinforce with our officers to keep that relationship of an exchange of information going. There's lots of different ways to support our victims and also the victims' families as well. I think we need to make sure that we support not only the victims but their families and those that are close to them, because there's also secondary victimization, and we want to make sure that we don't re-victimize the original victim. So it's not just the victim that needs to be supported, it's their whole family and those that are close to them.
Thank you very much. And I mean, I think you've commented a lot on it already, Paul, but, you know, is there any specific improvements that you could see that could be made that police can better support survivors for the very start of their interaction with the justice system?
I mentioned the interviewing unit. We always strive to make sure that we don't take too many statements from people. We need to make sure that when we interview people, we interview them appropriately with the least amount of statement taking and the interviewing that is possible. We need to make sure that we do it properly and we follow all the rules of law that we have to follow. So we're always making sure that we interview our cognitive interviews and child interviews as appropriately as possible. So our training is a key element for RNC officers. I mentioned improving our relationship with the community. We're always trying to make sure we're engaged with our community, whether it's a panel like this or sitting with any of the panelists here that our officers are involved with. The other thing I would mention that the minister touched on briefly was to support the idea of having independent legal advice to victims. It's a practice that's done up in the city of Toronto, Ottawa. I believe Thunder Bay also has it, where they provide legal advice to victims in an independent manner, independent from the police or from the court process. So the minister's touched on that, and we support that. We think it's a great idea, and we think that it could really provide another support for people of victims of violence and sex offenses.
Thank you.
And we're going to spend some time now looking at cases of sexual violence when they actually get into the courtroom. So we have perspectives of 3 different lawyers here. So from the perspective of a Crown attorney, from the perspective of a criminal defense lawyer, and also looking at civil litigation. We'll start with that Crown attorney perspective with Donovan Malloy, QC. And Donovan, in your experience, having been a Crown attorney and director of public prosecutions, what are the misconceptions that exist in the public, particularly among complainants and witnesses, about the role of the Crown in criminal cases?
I think the primary consideration, and I've prosecuted many sexual assault cases over the years, is that the Crown attorney is the victim's lawyer, and therefore should, is required to take instructions from a victim and to basically do everything that could possibly be done to get a conviction. And in fact, it is the complete opposite of the reality of the situation, which is that the Crown doesn't represent any particular victim or person, regardless of the nature of the crime. We present evidence that, the legalistic standard is to present all relevant and admissible evidence and to push it to its legitimate strengths, but not beyond that. Now, what does that mean? It means, number one, a Crown attorney doing his or her job can have absolutely no notion of winning or losing. So when you say, I'm not your lawyer and I'm not trying to win, in fact, I'm prohibited from trying to win, that's a major sort of shake in the foundation for somebody who has never had any involvement in the justice system. If you're lucky, you never will, and because the reality of the justice system is that it is structured so that the Crown presents the evidence. It has to be objective. It can't resort to emotions or things that would be prejudicial. And I can think of many examples. I had people tell me over the years, well, he's a drug dealer as well, and somebody said that he did this thing before. Well, number one, if it's not proven conduct, you can't use it anyway. And number two, unless an accused actually testifies, even evidence of things that he or she may have been convicted of before can't be brought into evidence, because that would be viewed as an attempt to prejudice the judge or jury, as the case may be. So you have these constraints on you as the prosecutor. You have to maintain your objectivity, but like any human being, you're sympathetic, you're empathetic, but you can't give in to that, because at the end of the day, you have to be objective. You have to consider evidence that may point to issues with the case being viable. So, unfortunately, we're inundated with American TV, both sort of fictional shows and coverage of trials where you'll see, large picture of the victim sort of in the front of the court throughout the entire trial. Well, we've got to fight sometimes about being able to introduce pictures of dead people during a murder trial. So when you tell people these kinds of things, the reaction ranges from "you're crazy" to "you just don't want to do your job," to any number of things, and that's why, I noticed the minister commented recently in a public interview about the potential for complainants to have, or to be able to obtain legal advice, their own legal advice. And that is, I think, would be a very welcome addition, because it is an alien system, and if you've never had any exposure to it, it's a real shock, a real awakening to find out that, no, the prosecutor is not your lawyer. Number two, he or she cannot try to win. And, number three, you got to give disclosure of everything in your file to the defense counsel, but they could call the Pope and you wouldn't know until his pointy hat came under the door. And you don't know what he's going to say. Now, that sounds extreme, but that's, it's an exaggeration, but it's truthful in essence. We can't introduce propensity evidence except in very limited circumstances. So there's all these restrictions that we have, and I know if I were on the other side of the table getting this information for the first time, I'd be disillusioned as well. It's information that you need to get really early on in the process, because if you don't get that education up front, I think it's almost a guarantee, regardless of the outcome, that you're going to be disappointed in the end.
Donovan, so with those restrictions on the role of the Crown, and keeping in mind the responsibility of the Crown to be impartial and dispassionate when it comes to a criminal case, could there be a possible role, though, or what role can the Crown play in both providing more support for complainants of sexual violence, and also playing a role in combating some of the myths that have been seen about how sexual assault victims behave or what their conduct is, and some of the re-victimization that we know occurs in criminal cases?
Firstly, I would encourage anybody who's coming into the justice system as a victim of sexual violence to avail of our victim services program. They have very good people there that will try and help as best they can. But at the end of the day, as best practice for a Crown attorney, he or she needs to, very early on in the process, as early as possible, to have the victim in and to discuss some of the things like I just mentioned in terms of how the system works. What do you expect the result will be? I remember similar conversations where, the victim would say, well, I think the outcome, you should go to jail for 10 years. And when you say, well, in reality, based on precedent, you might be looking at house arrest, probably at most. Well, that informs a decision, because the outcome, the original outcome, is totally unrealistic according to the law, but it's much more devastating if you don't learn that outcome was completely unrealistic until the day before sentencing, if there's a conviction. So, you really have to start in conjunction with victim services, in conjunction with your police officer, educating people about how the system works to make their expectations more in line with reality. So then they're proceeding through it on an informed basis, as opposed to, on what they believe it is, or frankly, what it should be. Other than, that, I think Crown attorneys have to be extremely knowledgeable of the laws of evidence and have to object vociferously, aggressively, to questions from defense counsel that serve no other purpose, or as their primary purpose, to invoke the rape myths that because, you had sex with somebody else, you were more likely to consent to sex with the accused. Absolutely ridiculous, should never be entertained, and a Crown attorney doing his or her job should jump up out of his chair and object to those questions. At the end of the day, unfortunately, notwithstanding how aggressively you object sometimes, at the end of the day, it's always up to the judge what goes in, what stays out. But at a minimum, when those types of questions are asked, that tend to be humiliating and denigrating, there have to be objections from the Crown attorney. So that's what comes to my mind primarily.
Thank you very much, Donovan. I'd like to turn now to the defense side of criminal cases, and Roselle and Sullivan, Rosellen, with the news stories we talked about at the beginning, locally, nationally, internationally, a lot of the discussion around those stories has been about the conduct of defense lawyers during these cases, and specifically, as Donovan was just alluding to, the questions posed to sexual assault complainants during cross-examination. First of all, how would you describe the role and responsibility of a criminal defense lawyer in any criminal case, but specifically in the context of cases involving sexual violence?
Okay, well, I'll start with that first, because the role of criminal defense lawyer is no different and can be no different in cases that involve allegations of sexual violence as they do with anything else. I brought along with me this evening my very trusty code of professional conduct, which is very clear to me, which outlines the parameters of the role of defense counsel. And I'm just going to read you a couple of sections from it, because it is, I'll just read them first and then we can talk about them. The guiding principle: the advocate's duty to the client, fearlessly to raise every issue, advance every argument, and ask every question, however distasteful, which he thinks will help his client's case, and to endeavor to obtain for his client the benefit of any and every remedy and defense which is authorized by law, must always be discharged by fair and honorable means, without illegality, and in a manner consistent with the lawyer's duty to treat the course with candor, fairness, courtesy, and respect. That's just the general for both Crown and defense and any counsel. More specifically, the role of defense counsel. When defending an accused person, the lawyer's duty is to protect the client as far as possible from being convicted, except by a court of competent jurisdiction and upon legal evidence sufficient to support a conviction for the offense charged. Accordingly, and notwithstanding the lawyer's private opinion as to the credibility or merit, the lawyer may properly rely upon all available evidence or defenses, including so-called technicalities not known to be false or fraudulent. And finally, I'm just going to read you one last section here, the role in an adversarial proceeding. And let's not forget that the court system is, by definition, an adversarial proceeding. It is governed by the presumption of innocence, and that cannot be applied any differently in a sexual assault trial than it can in a theft trial, than it can in a drug trial, than it can in any other trial. The role in an adversary proceeding. In adversary proceedings, the lawyer's function as advocate is openly and necessarily partisan. Accordingly, the lawyer is not obliged, save as required by law, to assist an adversary or advance matters derogatory to the client's case when opposing interests are not represented, for example, in ex parte or uncontested matters, or in other situations with full proof and argument inherent in the adversary system cannot be obtained. The lawyer must take particular care to be accurate, candid, comprehensive in presenting the client's case so as to ensure that the court has not been misled. So short of acting unethically, I have no choice but to advance any defense known to law. So when you talk about, I think Janet mentioned that the complainants often feel like they're lost in the system and they're not the center of the proceeding. Well, the reality is they're not. The accused person is the person who is on trial. The accused person is the person whose freedoms are at stake. So by definition of that, and by definition of the adversarial process, it's not, you cannot reconcile that with having the complainant at the center when the accused person's rights are the ones that are at stake there. So in terms of, and I know Donovan spoke about having complainants be made aware and be provided a lot of information as to the process. I fully think that has to happen right up front, and especially I think that's a good example in terms of, you know, if you have an unrealistic position on how this is going to end up in a sentencing, it's very helpful to know that early on. But also, there are limitations and there are guidelines for any court proceeding in terms of the example that he used about consent around sexual activity. You cannot ask questions about, well, because you consented to this before, therefore you're consenting now. There's an application. In fact, it's quite a structured process where in a trial, if the lawyer wants to go down that avenue, they have to give notice to the court, they have to file an application, they have to have a hearing before a judge without any it's an in-camera hearing, and it is solely to determine whether or not you can meet the threshold to go down the avenue of asking questions about consent. And there are very clear rules about that, and there are very clear rationale behind it. For example, you cannot, and I think Donovan alluded to the twin myths, you cannot call that kind of evidence by virtue of its sexual nature just to say, well, because you've consented before, therefore you're consenting now, or because you consented before, then you are less worthy of belief. It has to be relevant to the proceeding. It has to be relevant to a rule in issue in the trial, and then it's, like I said, in a private hearing for the judge to determine whether or not you can ask those questions or not. So it should not be a situation where a person is in a trial and bombarded with these questions. And often, unfortunately, that may happen, but there are rules in the system and in the criminal code that function to prevent that from happening as much as possible.
So it would seem there's still a sense among some complainants, some victims of sexual violence, that there is re-victimization happening within the trial process. There's still a perpetuation of myths about how sexual assault victims behave or how they conduct themselves. With the responsibility that you have to protect the right of your client to a fair trial and a vigorous, full answer in defense to the charges against them, is there any role for defense lawyers to play in trying to balance out or cancel out those myths and the re-victimization that occurs?
Well, I think that, because, as I said, or read in the first passage about mounting any defense, and however distasteful, and asking the questions however distasteful, you have to be very conscious of the rules around those questions. So you have to take those applications in advance. You have to take them, err on the side of caution and have it litigated beforehand so that you don't go down that road. And like I said, sometimes that doesn't happen, but that's how it should happen. In these applications, though, in my experience with them, oftentimes the complainant is not even made aware those applications are being made. So I think that more information being passed to the complainants is an absolute necessity. But in terms of the defense counsel role in doing that, I don't think that would be my role to do.
Okay, I want to move on in the interest of time. I'm sure we have lots of questions coming in the question and answer portion after the break. But I want to move on to Jeff Budden and to the role of civil law in terms of cases of sexual violence. And Jeff, it does seem like in many of the stories that we hear about legal matters involving sexual violence, most of the focus tends to be on criminal cases. But where does civil law fit into all this? Where does civil litigation fit into survivors of sexual violence searching for justice for themselves?
The way you ended it, for themselves, is sort of an important point. Criminal law, as Donovan and Rose Ellen have said, is really a societal matter where the accused is really at the center of things. The complainant is a witness. There are other agencies as well. There are advocacy groups. There is individual counseling. There is education. There are any number of other agencies that address those concerns, such as the group that I'm proud to be on as a director of, the Sexual Assault Crisis and Prevention Center. Civil law sometimes incidentally accomplishes some of those goals around advocacy or even healing or those kind of things, but it's not what it's primarily about. What it's primarily about is an attempt to get financial compensation for a harm that the complainant or plaintiff or survivor has suffered. And it's, I guess, rooted in a understanding that to be victimized by sexual violence is to experience great harm. There's the harm of the act itself, which anybody who has any kind of empathy at all can appreciate. But there's also harm that not everybody necessarily will appreciate, the harm that can affect a person over many, many years in ways such as your ability to get an education or earn a livelihood. And I guess what I do as a civil lawyer, what I try to do, is when a person comes to me and says, look, this happened to me often as a child, but sometimes as an adult or a young adult, I feel that I've been harmed, and I want to know, what can you do for me? I explain to them as best I can. This is about an effort to get financial compensation, to get you money for this harm that was done for you, to perhaps not only compensate you for the experience of the act of violence, but also the impact it has had on your ability to work, to get an education, to sometimes experience the full pleasures of a relationship, what legally is called loss of consortium. How civil law does that is some ways similar to criminal law, other ways quite different. It's different because there is no state there prosecuting with the resources of the state. There is the plaintiff with the resources the plaintiff may have or the law firm may have. There is a defendant who sometimes is a person who is being sued, but most often is an institution, a school board, a church, a government, who have their own desire, obviously, to protect the resources. So what we have here really is a battle, I guess to use that word, that plays out between two parties, the complainant, the plaintiff, on the one hand, who is saying, harm was done to me, you are responsible for that harm, I hold you accountable, and I want financial compensation. And the defendant that says something along the lines of, we deny harm was done to you, we deny this happened, or if it did happen, we as an institution were not responsible for the harm that this criminal did to you. And if we are responsible, we're certainly not responsible to pay compensation in the very high amounts you are seeking. So that all plays out following complex, arcane rules of procedure, which are similar in some ways to criminal law, but in other ways are very different. So we, for instance, in criminal law, the standard of proof is beyond a reasonable doubt. In civil law, it is different. It is more likely than not. So when we present a case, most often, practically speaking, it's through a negotiation, maybe a settlement conference, but sometimes it plays out in a trial. That is what we have to prove, that this happened, that it caused the harm we say it caused, that that harm could be quantified by these experts, and this is therefore why this institution should pay us, our client, these damages. When I said at the beginning, it's not really about healing, it's not really about closure. The law is a somewhat rigid instrument. It is trying, I guess, as it evolves over centuries, to protect various interests, including the interest of the defendant, who in most circumstances, at least the actions I do, are institutions that value their reputation and their resources and wish to preserve them. And the law respects that. So it's not a venue where the person is believed or where it's all about their own healing. Thankfully, there are resources in the community that address those needs, but it's not really the civil court process.
Jeff, where, if at all, does the civil and criminal process interact? I mean, I think there's sometimes a sense that it's one or the other, or they're mutually exclusive systems. And we get calls at Public Legal Information that seems to be misunderstanding about that. Where can there be interaction between those systems in cases involving sexual violence?
It has to be handled by all parties, I think, very carefully, because, again, the rights of the accused are very important, and we can have a circumstance where there's some sort of improper effort to get a conviction for some other benefit. That's wrong. However, so in many ways, the two systems have to operate parallel to each other, unlike in other countries. France, for instance, there is some intermixing. You can have a trial where where the accused is on trial and may receive a criminal sentence, and as well, there are advocates there attempting to get financial compensation for the complainant. We went down a different route in the development of our legal system. So there is some overlap, but other than in the sort of the special circumstances, such as Minister Parsons has spoken about recently, of perhaps delivering a very specialized legal service to complainants in criminal sexual assault matters, there's not really a whole lot of overlap.
Thank you very much, Jeff. I'm going to turn it over to Nicole now for the last set of questions before our break for Ellie Jones.
Thanks, Kevin. And so you're probably kind of getting a sense of the process today. We started with questions with Janet on specifically as a survivor-centered approach, start with the experiences there, and then the fresh entrance into the judicial system, which would be the police. Then we've gone through the judicial process. We wanted to bring it back to knowing that many we work with, what happens next after the judicial process, not only during. So we're happy to have Ellie answer some questions around trauma-informed approaches, and specifically from what is healing, what can justice look like outside the judicial system. Ellie, the first question we have is regarding, let's just talk about trauma-informed approach. It's a phrase that's often used in relation to working with survivors of sexual violence. For those that aren't familiar with this phrase, can you give us a little information of what it means in the context of the justice system?
Can you hear me? First, I totally thought if I sat in the middle of the table, I'd avoid going last. And it's wrong. So trauma-informed approach, I think in terms of distinguishing it from trauma-informed therapy, trauma-informed approach is for anybody. And I really believe, like, technically, if you're a human and you work with other humans, you can benefit from being trauma-informed. It's something that we could all benefit from, because trauma is a common theme in our lives. Experiencing trauma, going through things that are tough and hard, it's part of the human experience. And so a trauma-informed approach is really developing the compassion, understanding, and empathy for people who've experienced trauma and what they're going through. It really denotes that traumatic events can change people. They change the way they interact with the world. They change the way how they are in the world. It can change their relationships. It changes their responses to stress or to other events, depending on what their healing looks like after they go through a traumatic event. When we talk about trauma-informed approaches specifically in relation to sexual violence, or any type of violence really, trauma-informed approaches are survivor-led. They're often grassroots. They're informed by the experience of survivors, so it's what, as a survivor, have you gone through? While I'm talking, you're going to hear me go back and forth between the term survivor and victim, and that's because in some of the people that I've spoke to and the survivors that I work with are saying, now I'm a survivor. When I was going through my healing, when I went through experiences with the justice system or when life was bad, I didn't feel like a survivor, I was a victim. And it really depends on, some people, again, don't identify with either of those terms, but some people it depends on where you are right now in your experience and how you're overcoming things. Trauma can also, it may not be just a single event. So we talk about an incident of sexual violence, but we have to remember that people can go through an entire childhood experiencing some type of traumatic event or sexual violence throughout their childhood. It could be multiple sexual violent events, right? So all survivors are individual. It's really difficult to say, like, everybody, let's just get trauma-informed and use this approach. It can't be cookie-cutter. So while we can understand the principles of trauma-informed practice, which is really about giving control over to people who've been victimized and who are survivors, it's about going and understanding their individual stories. It's individualized, so it's a broad philosophy that allows for the understanding of people as people and their own interpretations of their experiences. It recognizes the individual and what happened afterwards. I think in relation to the justice system, what we're looking at is a real juxtaposition between what is the best interest of the person who's experienced that traumatic event, and what are the needs of the justice system. And both have needs. I'm cutting in and out, I'm sorry. So the justice system has a job to do, and a survivor or victim also does. Their work is in the healing. And sometimes the needs of the justice system and the needs of the survivor are not the same, and they actually work against each other. And that's where we see poor outcomes for, unfortunately, usually our survivors. There are different approaches that you can take depending. Embedded within a trauma-informed approach is using things like restorative justice in order to help bring understanding and healing to survivors. So when we talk about impacts, I think that's our next one, hey?
Absolutely.
Okay.
So, and maybe a little bit, Ellie, if you could talk about, what should stakeholders in the judicial, including police, lawyers, judges, court, and others, know about the impact of trauma?
When we talk about the impacts, I think any violence, we talk about the victim or the survivor as center and core to that act, but what we see is actually ripples of violence within our community. So you have the person who is most directly impacted, who is the victim or their survivor, but then we see their families impacted as well. And then outside of that are people who experience secondary and vicarious trauma. So that's our police officers, our first responders, it's our Crown lawyers, it's our defense lawyers, it's judges. It can be people in victim services, it can be sheriff's officers. All of these people are exposed to the violence within our community and have had their own life experiences, and how they interpret these events impact how they work then with other people. So it's really a ripple effect, and that's why the trauma-informed perspective is so important, because it's about providing healing for the whole community. And as a community, it's our responsibility to ensure that everybody is safe and healthy. And by only the victim and the survivor, they are central to that. We all want to keep people safe and keep people healthy, and also work on prevention. And the only way we work on prevention is to be able to understand that these violent events are ripples within our community that we need to work on. So there's a risk for, in terms of our first responders or judges or police officers, in different instances, to experience things like hypervigilance. So they become concerned around over-prosecuting or being overzealous in terms of getting information from people, or they shut down and choose not to pursue certain things, or to be able to hear the information that they're being given from survivors because they can't hear that anymore because they're not in a place where they're able to work with that. They've been traumatized. In terms of our survivors, it's really important to know that their own experiences are so impacted in how they remember. And I was kind of doing my notes, and I was like, I can't do a neuroscience lesson at the panel, so but I'd really love to, because it's really cool from that perspective. It's really awesome. So invite me to your office, and I'll teach you about brains, because it's really interesting. But when we talk about what happens to survivors, there's a huge, massive emotional impact. So how they, their feelings of self-confidence and self-efficacy, being able to be out in the world. You see mental health issues around anxiety and depression. I think the thing that people don't realize is that there's another whole layer beyond the emotional that we don't often see, because there's a physiological reaction to trauma. So the way that our brain interprets a one single traumatic event, we can have distortions in time. Have people not really clearly remembering. So people have this idea that if an event is traumatic, you're going to have this crystal clear memory and remember every detail. The reality is, depending on the life experience of the person who experiences that event, they may not be able to recall that. And they may not be able to be exact in dates and times of days. They may feel like something lasted forever, or they may not clearly remember it because when they were being harmed, they dissociated and left their body because it was the only way that they could sit there and take what was happening to them. And that these pieces are critical in terms of understanding credibility. So a lot of the people that I work with talk about, but I'm afraid that people are not going to believe me. I don't clearly remember my childhood rape. And they don't clearly remember that because their brain did them a favor and blocked it. You don't have to remember this, I'm going to take care of you. And that's true for many people, many survivors of all forms of violence, but in particular sexual violence, because it's such a violation of your body. So I think when we're talking about what do we need to know, it's that people do the best they can to be honest and to bring things forward, but the best that they can may not be what the justice system wants to hear. They don't have the capacity to bring it forward. And we need to have compassion and understanding for that for people.
Thank you very much, Ellie. Is just to give you a quick note, because I know that we had another third question, but I think you've answered it very well. Is there anything that you feel the justice system can be doing better to reflect a trauma-informed approach?
Well, actually, it's funny because it's come up a couple of times in this panel. I had one of my survivor friends, she said to me, "You know, the Crown is not our lawyer." And I was like, I know, which has been clear tonight as well. And so I think an independent third-party person who can represent the needs of survivors and victims and bring forward a very clear voice in terms of what's happened to them is very important. The other thing that we've talked a lot about with survivors and other folks is around the media and legislation protecting survivors and victims. The public may have a right to know the perpetrator, but in terms of knowing exactly who those victims are, no matter what their ages are, and these are often people who are mothers, who are sisters, who are aunts, nieces, who are sons and daughters, they might not be in a place where they can appropriately answer questions from the media. They might not be in a place where they can make a fully informed choice about being present in the media. And we live in a very small province in a very small city, and it's pretty easy to identify who it is just by their age and where they live, kind of thing. And so we've talked about, how do we do that protection? Can there be media education through victim services for people going through a court process to understand that, when you're asked certain questions outside of a courtroom, you don't have to answer that. You don't have to say that. Is there legislation that we can put in place to further protect victims so that if they choose to share their story, it's on footing that they're in control of? It's not outside a courtroom after coming out from a decision or a judgment or a sentencing of a perpetrator where they might not be, your adrenaline is running so high, and are you thinking clearly? Maybe not so clearly, and you're talking about people who've been very violated, and so do they know or feel empowered to say, I'm actually not going to answer that question right now because it's none of your business. So I think looking at those kinds of things and having a really kind of good discussion around how do we protect people in our courtrooms is important as well.
Thank you very much. Folks, we are going to take a break. So we'll take about a 10-minute break. So great job. Phenomenal questions. So myself and Kevin were quickly doing is trying to synthesize some common themes and ideas so that we can keep you here on time and also offer what you are looking for answers. So my first question is to the entire panel, and feel free to begin or jump in where you want to. And this was certainly a large theme and an important theme. Many questions focused on the futility of the justice system. Specifically, we're asking, what would you say to a survivor of sexual violence who is going through the system and regarding the issues that it's faced around harm occurring, re-victimization, the length of the process, and the outcomes different than what the initial expectation was, and the lack of supports. What would you say to a survivor?
I think it's really important for all of us, regardless of our backgrounds or what it is that we're doing in our jobs, to be validating the concerns and experiences of survivors and to be honest that the process is long and that it is hard, but that they're not alone in that process, and that at any point that they have ability or the capacity to make a decision to do what works best for them in that moment. Try and shift some of the responsibility that society and the community is putting on them. Try and take a step back from that and to do what they need to do in order to keep themselves safe. To find people in their lives that can be support people for them through the process. You know, when we talk about the system and how it is so adversarial and how for so many people it does feel futile, looking at what would be helpful for you in this moment and prioritizing and highlighting the need for self-care. Because self-care is always important, but when you're going through a process like the judicial system that exists in our country, you really need to be focusing on self-care and what you can do for yourself.
Thanks, Janet. Anyone else like to offer?
Yeah.
Thanks, Ellie.
I think self-care is very important. Part of that, as I suggested before, involves being as informed and becoming as informed as one can about the process so that one understands what's involved before you sort of get to the end of the process. I think that's an obligation, victim services, the police, the Crown, to make sure that people understand how the system works. You know, there are other things that can be done, as it might be going slightly off topic, but you know, there's a community of people here that are interested in the issue. The criminal law is made by Parliament. Parliament's not going to change the law unless enough people ask for the law to be changed. The whole topic of sexual assault got a lot of attention recently with the trial of Gian Gomeshi. It seemed like that was going to be a springboard into possible, you know, to get people talking about legislative change. But, you know, in regards to a recent issue in the news about people not being able to have pictures of their loved ones in court, their deceased loved ones, you know, Parliament could easily say you're entitled to have a picture there unless the judge determines that that is going to interfere with the administration of justice. They took a step when they said you're entitled to have a picture of your loved one when you're giving your victim impact statement. But even then, it's qualified by the caveat, well, but not if it's going to disrupt the judicial proceedings. You know, so the criminal law is made in Ottawa. Ottawa is only going to change the law if enough people move for it to be changed, enough people want it to be changed. You know, and that's everybody who has an interest in these things, writing the Minister of Justice in Ottawa, because that's how the criminal law gets changed in this country. Our own Attorney General, you know, only gets to sit in on meetings once or twice a year where it gets input, but the decisions ultimately are made in Ottawa. So, you know, if you really want to try and see things change, those are the people in Ottawa who've got to be motivated to change things, and they only get motivated by action, by something getting enough attention that they feel that, you know, they've got to change things. So that's my comment.
Thank you.
With regard to that question, it's what people are hoping is the outcome of their interaction with the judicial system. And often we talk to survivors who hope for closure and are often left feeling disillusioned, really let down, and that they weren't represented or their needs weren't represented. And so in talking to people about that and that disillusionment, it's really more about where does healing come from? And you can have lots of external supports, and they are important, but that healing happens within, and it's time and it's work that people have to do with the supports in place. And I think it's really important, though, for everyone to realize that healing is possible for everybody. And most people do come out on the other side, and they do come out on the other side doing well, and come out on the other side supporting other survivors and participating in different groups, or just going on about their lives and being a happy human. And that's possible for everyone. I think it's important that we don't encourage people to stay bogged down in the pain and to stay bogged down and angry at a system. I think it's important that people have avenues to be able to advocate for change, and advocate for that change when they're well and feeling ready to advocate for that change, not when they still feel victimized of a system. And it's important for those of us who have come out on the other side to be the ones supporting that, and that there is a community that can help people.
Thank you. Would anyone else like to touch base with that? If not, we're going to move just for time to an. Sure. Yep.
I know we're talking about after the process, but I just want to underscore that victim services as well for people throughout the trial, because I think the outcome is a lot of issues at the outcome, but certainly guided throughout the trial. I know we talked about the possibility of legal advice through the trial, pre-trial, or at any point after the complaint is made or the assault has occurred. But victim services they're a very passionate group of people as well, notwithstanding the people at this table for sure, but they're also very passionate about what they do, and I think they play a very important role with the victim, support them through the court process. And I know victim services, when a couple of them saw my name was speaking at this panel tonight, they sent me several emails, long emails about what they want to put forward. So they very much have the interest of the victim at heart, and they try to help that person throughout the whole trial process. So they play a key role as well.
I actually just wanted to follow up on what Inspector Woodruff just mentioned, because we did have a question about the role of victim services. And it's been mentioned a few times during the discussion with the panelists about the possibility of a need for independent legal advice for survivors of sexual violence. I mean, if there is a feeling that victims' rights are not being represented, that there's a lack of understanding of the legal system, is that a message that the role of victim services needs to change, perhaps needs to be enhanced in some way, or in combination with other supports that are out there to better serve victims of sexual violence?
Victim services, and the defense are probably in a better place to answer this, but victim services works with the victim in the courtroom long before they get to the courtroom, but they don't advocate, or they wouldn't have standing in the court system. See, a change like that would be pretty dramatic and would have to be done in the government system, the federal government, the way that the courts and the trials are done, but they do have a huge role in prepare people for the trial and the process and the outcomes, and also the type of expectations during the trial.
Victim services, the workers aren't lawyers. That's why it has to be a cooperative relationship between them and the Crown Attorney, involving them and the Crown Attorney, so that they act, I would say, as a liaison, as a facilitator, but ultimately the legal information should be coming from the Crown Attorney. You can't really expect victim services workers to be responsible for answering legal questions.
We've had victim services in Newfoundland since, I believe, about 1990, and the roles they play include helping prepare victim impact statements and so forth. And the Crown prosecutors, and all the time I've been part of the justice system, obviously do meet with complainants and other witnesses, but they have many other functions going into a trial. So, and again, this is a suggestion that came from the minister a couple of weeks ago. There may well be a role in the system, as there is in some other places, for the provision of advice of at least a general nature to complainants in all crimes. But since we're talking about crimes of sexual violence here, that is where the I guess the focus would be. There are problems there. And again, it comes down to the emphasis within the system for good reason on the rights of the accused. And what I don't think would be problematic would be a lawyer meeting with the complainant and saying, this is essentially what your role is. Here is a witness. this is the kind of question you might expect. Your emphasis must always be on telling the truth. Don't get upset or defensive as best you can. And I'm sure the Crowns do this now, but again, the Crowns have so many functions, the Crown prosecutors, that perhaps some individuals feel they are lost in the shuffle and don't have that type of legal advice. But there are some inherent problems with that. As I said earlier, in some countries, the counsel for the victims, the survivors, are right there at the table in court, questioning, making demands, having rights. But that's, in order to have something like that, would probably require constitutional changes or other systemic changes way beyond what our current adversarial system of criminal justice would allow. That's my thoughts anyway.
I think, Kevin, it's also important to be mindful of the capacity and resources available to the different offices. I mean, if we're speaking specifically about victim services, recognizing that some regions in the province have one victim services worker for a huge geographical area. And is that truly an accessible service to individuals who are living in rural or isolated areas who also don't have access to the supports and services that we might have in St. John's? So keeping that in mind too, when we're talking about some of the amazing supports and resources that exist in the community, how accessible are they to our rural counterparts?
Well, if your matter's going to court, there's a victim services worker in every court location in the province, and they are available by telephone. I realize that's not the same as in person, but I think they are at every court center, and they do make their best efforts to get in touch with people who wish to avail of victim services. But it's, I agree, things are more challenging because we have a large province. Our population is spread out, throughout the province. It's a challenge, You talk sometimes about best practices, but, the average Crown attorney, the average victim services worker has hundreds of files as well. So, you want people always to be engaged in the best practices, but, there are some times when, people are trying to do their best and unfortunately occasionally make mistakes because the justice system is administered by human beings, and unfortunately human beings sometimes do make mistakes despite their best efforts and best intentions. And I realize there's no solace if you're the person in regards to whom a mistake has been made, but most of them are trying their best and want to do their best.
I wanted to ask about a group we actually haven't talked a whole lot about tonight, which are judges for cases, especially criminal cases involving sexual violence. I had a couple questions about whether judges are required to take any sensitivity training or continuing education generally in order to maintain their position, their role as a judge, and also about training in general on properly applying the rules of the system. I suppose further than that, what kind of oversight or what kind of action can be taken for judges that aren't properly doing what they're supposed to be doing, or perhaps, as we talked about earlier, perpetuating some of those myths around sexual violence?
The timing of this panel is coincidental with the current ongoing proceedings in regards to Judge Robin Kemp, who infamously and despicably commented to the victim of sexual violence that asked her why she didn't keep her knees closed. I mean, there's in my memory, plus 20 years, I've never heard anything so ridiculous and despicable, and to come from a judge makes it so much worse. Forensic court deals mostly with criminal matters. You know, so if you were to make the analogy of provincial court to a hospital, and you have a hospital, but your hospital only does, or primarily does, orthopedic surgery, but for some reason, you know, all the other doctors want to work at this hospital. And so you have neurologists, psychiatrists, podiatrists, you name it, applying to be a doctor at this orthopedic hospital. They get appointed. Robin Kemp was a construction lawyer, a civil lawyer, who got appointed, not only appointed to provincial court, but he got appointed to the head of domestic violence court. He's admitted in the proceedings that he had no knowledge of criminal law, was totally unaware of the sexual assault myths, and yet, you know, shortly after being appointed, he's presiding over a sexual assault trial. And so, you know, you say to yourself, well, how does that happen, you know? How do I go to an orthopedic hospital and have a psychiatrist replace my hip? Well, you know, what do you think is going to happen? You know, we had a recommendation from the Lemaire Inquiry years ago, which was focused on wrongful convictions. And one of the recommendations that they made was, you know, to have experienced criminal lawyers, have not exclusively appointed to, especially Supreme Court, because they do deal with a wider variety of matters. But, you know, but he just didn't, someone didn't make him take that job. He applied for that job, took the appointment, agreed to be in criminal division, and now he's, you know, saying, well, ignorance of the law, I didn't know. But I challenge any of you to try that on your next traffic ticket, that you didn't know what the speed limit was. So, you know, there's fundamental things as well that sort of, you know, you got to look at it from the foundations up. And you know, I just think that's just such a polarizing, terrible example of judicial insensitivity. I mean, regardless of the fact of what he knew or didn't know about the criminal law, I mean, that's just completely insensitive and inappropriate. But, you know, he applied for the job, and now he's saying it's not his fault that he didn't know how to do it.
Go ahead. Go ahead, Janet.
I can't speak specifically to judges and the training, the continuing education, et cetera, that they do or they do not receive. But I made a similar comment last Friday morning at our provincial proclamation signing that what that individual said to that survivor is something that a lot of people are saying to survivors all of the time. And so this evening it seems like we're recognizing a lot of the problems that exist, and we have come up with, I think, a couple of solutions and or things that could move some things forward. But ultimately what we could all be doing is preventing secondary wounding and preventing victim blaming and standing up and speaking out when we're hearing things like this, because what he said is in fact not that outrageous. It is incredibly common, and people are hearing it all the time. And the majority of the people that reach out to us and call our 1-800 number are describing experiences with secondary wounding. And so all of us can ask ourselves, what can I do to do better? What can I do to prevent this? And what can I do to break down the myths and misconceptions and culture that exists where someone would even be in a position to say that in the first place?
Rosellen, did you want to weigh in on this as well?
I was just going to say, just in relation to the judges that are now in provincial court, as Donovan said, most of the stuff in provincial court is the criminal stuff. And in my experience, all of the recent appointments, and I think you can probably weigh in on this as well, are certainly much more informed on these types of issues than they ever have been in the past. And a lot of them maybe not practice exclusively criminal law, but certainly some. And I think that they are, and I do know that they do have training programs specifically for sensitivity around this area. I don't know how the extent of the programs, but I am confident. I would say the last 6 or 7 appointments, I would be 100% confident in their ability to recognize the issues and hopefully keep the, you know, and they are the gatekeepers of the process as well. So it's, you know, it's up when things are going off the rails, it's up to the Crown attorneys to object or defense counsel to object, but it's ultimately up to the judges to keep things on the straight and narrow. And I do think that our provincial court bench is in the best position that it has been in since I've been around to do that.
Yeah, yes, I mean, Robin Camp's in Alberta. I don't know what their situation is. Obviously, doesn't appear very good right now, but we are very fortunate in this province to have the majority of our judges in provincial court who do have related experience, related previous experience. And I don't mean to say that just because you don't have the experience that you can't do a job, because there's many judges who come from different backgrounds, but they're willing to put in the work. They do the continuing education. They learn, and they're quite willing to learn. But I just think in provincial court, especially where the majority of the work is criminal, that it has to be an asset that you have related criminal law experience, that you actually know what the criminal code is, and you've picked it up before. And Supreme Court is different because they do deal with a lot of different matters, but unfortunately, regardless of the Lemaire recommendation, in my view, there are not enough lawyers appointed to Supreme Court who have criminal, significant criminal law backgrounds. And, you consider in Supreme Court, it's the most serious cases that we have in society. I think there's room for improvement there for sure.
Jeff?
Sure. My experiences in Supreme Court where civil matters are heard, not in provincial court, which is mostly criminal. And it's different up there in a number of ways that are important. One is that not a whole lot in Supreme Court actually goes to trial on its merits. In criminal court, somebody's charged. They mostly end up with a trial, unless there's some intervening event, such as a stay application or the charges are withdrawn. But in Supreme Court, I don't know the stat off the top of my head, but it's well over 90% of all actions that are started are settled or abandoned or resolved through mediation or something like that. So what we mostly have up there would be disputes about whether or not you as defense counsel or as plaintiff's counsel are entitled to certain documents, or about whether a particular witness or a particular expert is qualified to give advice. So it's not as you would typically get in provincial court about how the demeanor of the judge towards a particular witness, be it a complainant or an accused or anybody else. It's mostly about fairly arcane areas of law, and it's fairly bloodless, like you're arguing about statutory interpretation and things like that. So it's, even though obviously underlying it all is the attempts by a person to get compensation for a wrong done to them, and the attempts of usually an institution to resist that claim, on the ground you're mostly battling about the scope of the discoverability rule or something like that. So, and lawyers and judges are all pretty good at abstracting. So that's been my experience. You hardly are dealing with people as individuals, you're dealing with concepts.
I think we're going to move on to a couple more questions. One is, we've had a couple questions about the potential role for restorative justice in cases involving sexual violence. And I think this may go more so to our looking at beyond sexual assault cases to perhaps cases involving sexual harassment. The Dalhousie dentist scandal comes to mind where restorative justice was applied. So we had one question, which was if our panelists could speak to the potential benefits of restorative justice for cases of sexual violence. But we also had a question stating restorative justice has been criticized because it can reinforce power structures and force victims to make unwanted concessions. And so is there a specific model of restorative justice that may be most effective and keep that potential power imbalance in mind? Anyone who wants to weigh in but Ellie, if you want to start, yep.
So with regard to restorative justice, I mean, it's highly aligned when we talk about a trauma-informed approach. One thing that we always caution people of around restorative justice is that it has to be done by people who are trained and it has to be done appropriately. You need to have both parties consenting. I think the cases where you see reinforcement of power structures and people giving concessions and those types of things, it's often because it was a poor process of restorative justice, so it wasn't concept necessarily of restorative justice, or it was the way that it played out in terms of the education of the mediators who were brought in, or working with the people who were harmed and who did the harm. And the reality is restorative justice reflects the responsibility of all of us to keep our community safe. And when we still talk about why do we still have issues with sexual violence, why do we still have issues with intimate partner violence, we do a lot of work with victims, we do a lot of work with survivors, we also do a lot of blame victims and survivors. Very often we're missing half of our equation. So how often have we sat down with perpetrators and said, dude, do you know what you did? You know what you've done to this person. Do you understand that house arrest? Now, a mom, home, or whatever house arrest looks like for them. Is there a full understanding of the harm that you've done to this person? Do you fully understand how you've impacted her life, her children, relationships, whatever it is? And so without involving perpetrators in fully understanding the harm that they have done, sometimes people don't realize the extent of the harm. It can be their own experiences. It can be their own understandings of culture and many things that cause people to be perpetrators. And we need to be open to that and to understand that as much as victims and survivors need support, perpetrators need education. We can't create change without educating not just perpetrators, but all of the people in our lives who potentially could be that. We need to include boys and young men in the conversation of violence. We need to teach boys and young men what consent means. We need to teach them about it's beyond no means no, it's about basic respect. And we need everybody to be educated in that. And so restorative justice is a way to bring them into that conversation in a way that helps them understand, and it allows us all to take responsibility. So it can be very effective, but I would caution in terms of violent sexual assault and those types of things, restorative justice may not be the road to go down. It's not a healthy place for people where there's extreme violence. It doesn't mean that there can't be perpetrator education, but that is not the place for that. There are people trained in this province in restorative justice at Memorial University through the Restorative Justice Consortium, who I think maybe at a future event you'll hear from. But it can be an effective way. But again, the key as with anything, is that you have people who are trained and who are knowledgeable in the process, and that people are protected. And the key in restorative justice being effective is that the victim is protected and willingly participating in a way that's safe.
And I think that's an issue that hopefully, like I said, this is not a one-time only event, and there's a lot of other issues to explore in future sessions as well. I think we're going to try and squeeze in one more quick question by Nicole, and then we'll wrap it up.
So there was a lot of ideas that folks had offered as support. This is a matter of looking at best practices. So there was many ideas of what could be out there, such as specialty courts for sexual violence, appointing advocates to work with someone going through the whole thing. Also looking at training, specifically around trauma-informed training for all aspects of the judicial system. Having a sexual assault nurse examiner within all areas of the province installed, working with community workers to look at that. I mean, there's a lot of best practices that were kind of thrown out there from the audience, and we're going to keep all those because that's a great starting point and for our next conversations. But I'm wondering if people can kind of, amongst some and the other many ideas put out there, is there any best practices or anything you'd like to leave us with regards to moving forward and ideas that could be put forward as to enhancing or increasing or making things better?
I think in terms of enhancing and making things better for survivors, the number one thing that we need to be doing is talking to, but more importantly, listening to survivors themselves. And I think that the ongoing conversations need to be led by survivors when they're in a space in their healing process to do so, because best practices ultimately are mostly going to affect them. And so it's important that they be part of the conversation.
Thank you, Jen. Does anyone else like to comment?
The domestic violence court that has been in operation for a year again now, I think it'll be interesting for when we talk about restorative justice and different ways to handle cases and files, the successes that are coming out of the court there, because they've been running up and running for a year across the province. It's getting bigger, so it'll be interesting on the next forum talking about restorative justice to include a component of that.
Right. The importance of...
I got the technology.
I know, I had the cool microphone, but I don't know how to use it. The importance of the survivor-led grassroots initiatives within the city and within the province, and how important they are. And when we have opportunity for our survivors to lead and support people who are victims, that we give space to that and figure out ways to make it happen.
Thank you.
I just, knowledge is power. This type of engagement is very valuable. And I'd like to thank you guys for organizing this, because I think it's the first time I've participated in something like this, and it's been very valuable to hear the insights of everybody on this panel. And I think, if we can increase these opportunities, it would be very beneficial as well.
That's great. Okay.